Good evening. Welcome to this President's Day edition of Newsmax Prime. I'm J.D. Hayworth. Of prime interest tonight, the death of a legal giant. Antonin Scalia was not Chief Justice, but he was the chief proponent of conservative legal theory in our nation, and his passing leaves a tremendous void. Miranda Khan has more on the consequences of Scalia's death for pending cases, the procedure to appoint his possible successor, and the future of conservative jurisprudence.
JD, to say that Antonin Scalia was one of a kind is not simply a slice of rhetorical flattery. He was the foremost practitioner of originalism, the legal theory that views the Constitution's meaning as fixed as the time of enactment. Simply stated, it's a notion that we should follow what our founders said in the Constitution and the exact way they said it. The Constitution says in Article 2, Section 2, Clause 2, that the President, with the advice and consent of the Senate, shall make appointments to the Supreme Court. Lawyer and talk show host Hugh Hewitt has some simple advice for the Republican-led Senate. Do not consent to an appointment by President Obama.
But if I were a Republican, whether the majority leader all the way down to the county clerk and every nominee, I would say very simply, no hearings, no votes, lame ducks don't make lifetime appointments.
President Obama probably doesn't like being referred to as a lame duck, but he is in the final year of his presidency. And in the hours following Justice Scalia's death, he made it clear that he intends to try and appoint a successor.
I plan to fulfill my constitutional responsibilities to nominate a successor in due time. There will be plenty of time for me to do so and for the Senate to fulfill its responsibility to give that person a fair hearing and a timely vote.
Now, conservatives view Scalia's passing as untimely as well as unfortunate. As our parent website, Newsmax.com, reports, Scalia's death will, in all likelihood, allow public employees' unions to continue their collection of mandatory dues and use them for political purposes. Oral arguments have been heard in that case just last month, and Scalia appeared poised to lead a 5-4 majority. That would have stopped the mandatory collection of union dues. But now, with a 4-4 tie, the lower court ruling in favor of the unions would stand. Other pending decisions include a Texas immigration case challenging the legality of President Obama's executive orders on amnesty, another Texas case concerning that state's strict abortion law, and yet another case challenging Obamacare, specifically the government's current mandate requiring the Little Sisters of the Poor and other religious groups to cover contraception in their health plans, despite their strong opposition on spiritual grounds. So, will the ground shift around the Supreme Court? Philosophically speaking, well, that remains to be seen. JD, back to you.
Thanks, Miranda. For more, let's welcome in the former Assistant Attorney General at the U.S. Department of Justice, John Yoo. John is now a professor of law at the University of California at Berkeley. Also joining us, professor at Harvard Law School and Newsmax contributor Alan Dershowitz. Alan, of course, the author of the book Abraham, the world's first, but certainly not last, Jewish lawyer. John Yoo, let's start with you. You're out there in California. The case about mandatory union dues involved the California teachers. How big a setback is the passing of Scalia in this case and others coming before the court?
Scalia's passing means that the current policy that unions can force all the employees in a workplace to contribute money to political donations and political speech that they disagree with is going to stand. I think that there was a 5-justice majority that's been slowly expanding the rights of free speech in the area of campaign finance and so on, and that's, I think, now out the window. So you'll have a 4-4, at least a 4-4 tie, and that means that the decision here out in California would stand, which upheld the law. I think on a number of other cases, though, facing the court, I think Justice Scalia's unfortunate death is not going to change things that much, at least for the next year. That's because on some of the cases, like there's an abortion case right now, the court was likely to strike down the abortion law anyway. Justice Scalia would have been in the dissent. An very important affirmative action case in Texas. The liberals also have a vote. One of the justices recused, so the conservatives probably, I think, would have won that case. But in general, what happens when there's this tie, this case is below stand, which means that the next appointment becomes even more important, because that's the thing. The next person who's going to take Scalia's seat will break those ties and will, of course, be on the court for the rest of their the lifetime. So they're going to be a decisive change, and they could be a decisive change in the balance of the court right now, which is finally attuned, I think, with 4 conservative justices, 1 conservative fifth justice that's kind of in the middle, and then 4 liberal justices.
Well, let's talk about the next possible appointment, Alan. Of course, we heard the president saying he's going to go ahead and appoint somebody in a timely fashion. Some worry about a recess appointment, but as my colleague John Gizzi pointed out at Newsmax.com, we think back to 1968 when Chief Justice Warren was retiring. LBJ tried to put Justice Abe Fortas into that job. That didn't happen, and then the consensus was, wait, it's called the LBJ precedent. Is it worth following now?
No, I think the president will make an appointment. It won't be a recess appointment. There are 2 strategies he could follow. He could appoint a kind of traditional liberal, knowing that it will be rejected, in order to make this a campaign issue so that whoever the Democratic nominee is will be able to argue, look, your daughter's right to have an abortion may be at stake in this election, vote for us. That's one strategy he could pursue. The other, which is far more likely, is that he will try to find a moderate, perhaps somebody who was appointed to a court of appeals by a Republican president, or somebody who has kind of credentials on both sides, maybe somebody who represents an ethnic group that has never been on the court before, an Asian American, for example, and make it harder for the Senate to reject. Another possibility is to appoint a sitting senator, like a Cory Booker, who has all the liberal credentials, but the Senate often defers to their own and has a hard time rejecting a sitting senator. So these are all the options that are now being considered by the White House. I think the president will go with the middle option, that is, to appoint a moderate of an ethnic background that would be hard for the Republican-controlled Senate to reject.
Well, that's a curious thing. I don't know if that, in fact, is going to happen. But let me bring up something else. You know, ironically, Friday afternoon, I sat down with Justice Stephen Breyer and talked about the prevalent notion that the Supreme Court should cite foreign courts and their cases in cases that come before our own Supreme Court. Let's listen to Justice Breyer and his response.
What I say, and I think you have a very good point, is what's worrying people who are worried about referring to foreign cases or what goes on abroad is, will we lose or dilute our own American values? I think you'll agree with me that the best way to secure our own American values is to be aware of what's going on beyond our shores and to take appropriate account.
Yeah, okay. John, you taking appropriate account, is it appropriate to cite foreign cases when discussing constitutionality in the U.S. Supreme Court?
I don't think so. When this practice first started about 10 years ago on our courts, I wrote a small piece called Against Foreign Law, because I don't think foreign law has any authority in our legal system. That was the whole point of the American Revolution, is that we didn't want to be governed by laws made in other countries. I think what Justice Breyer's point there has some truth to it, is that there's nothing wrong with knowing what other countries are doing. But in terms of how we decide our own legal and constitutional issues, I don't think that foreign laws, foreign decisions should be given any respect as authority or precedent by our own judicial system. And I hope Justice Breyer isn't going so far as to say that, because that would, I think, represent a fundamental transformation of ideas of what American sovereignty is about.
Alan Dershowitz, let me ask you, it's one thing to be aware of these cases, as John Yoo points out, but to cite international cases, isn't that like surrendering American sovereignty?
This didn't start 10 years ago. This started 210 years ago or 230 years ago. If you look at the earliest Supreme Court decisions of the United States, they're filled with references to British law. In fact, it was argued that one reason we fought for our freedom was we wanted the right to have British common law. British common law, Blackstone was cited all over the place. Obviously, our laws were derived in large part by the laws from the laws of Great Britain. If you go through the 19th century, you see citations to foreign decisions, mostly British, but not all British. We live in an interconnected world. Boundaries don't today stop the internet. They don't stop the climate. They don't stop antitrust. They don't stop terrorism. So I think it's very important to know what foreign law is. Now, obviously, in construing the Constitution, you look at the constitutional history. So I think it's always going to be a matter of degree, but I think Republicans have taken this issue and exaggerated it, saying, oh my God, we're becoming creatures of foreign law. American cases are decided largely by American law, but if you want to look at the trends relating to capital punishment around the world, it's relevant that we are the only Western democracy that still executes. It is relevant to see how other countries treat the issue.
And that point is well taken. Pardon the interruption, but again, there is the notion of American exceptionalism. And John Yoo, there's something else that people worry about, especially if President Obama nominates someone, and that is what becomes of our Second Amendment. If the court goes the other way 5-4, do we say goodbye to the Second Amendment?
I think it's a good question. I think, again, the court is very finely balanced on a lot of the most important issues. It is split 5-4, and Justice Scalia's seat would make the difference in the outcome. And you're right to point to the Second Amendment cases, McDonald, City of Chicago, and so on, and Heller versus District of Columbia. These are cases where Justice Scalia wrote the majority opinion. He really was the fifth vote. I think if President Obama fills that seat, given what he said publicly, and I think his constitutional views, he would appoint someone who would have voted with a dissent in that side and would have overturned any kind of individual right to bear arms, or at least subject it to very significant government handgun regulation. But I think it's not just that. A lot of First Amendment cases. There's, I think, a whole number of cases involving religion,
and
race, and affirmative action.
Suffice it to say, the ideological fault lines are replete in our system. John Yoo at Berkeley, Alan Dershowitz Skyping in from Miami. Gentlemen, you have our thanks. You heard what these two respected legal minds had to say. Do you agree or disagree? Send me your comments at newsmaxtv.com.